Welcome back to the paralegal counseling training, and we are looking at debt correction or debt jurisdiction. So today we are concluding this course on debt law, starting with the debt collection. So join me in this lesson. Here is Dr. Tulipo Mwenifumbo.
Yes. If there is a most one of the challenging laws which are very difficult to apply and to work on or to prove is the debt law. So now, what laws governs debt correction? Uh, the first thing that should govern the debt correction in debt correction is that one has to there must be a contract before the debt is made. There must be a contract before the debt is made. So you cannot just like there are many cases whereby there are many cases whereby someone just says, okay, you want borrow me some money. Then, when are you going to pay? No, I'll pay at the month end. Okay. Then this person borrows you the money with a contract of repayment at the month end. Then after 2 days, this person comes back and said, I've got a problem. I want my money back. So in such a case, there are laws that governs the debt. So I said the first thing concerning debt is that uh, there must be there must be a contract, and a debt mostly when it is also has to do what is called the interest. If there was no interest in the charge of the debt when it comes to money, then there was that debt was on friendly basis, and mostly it has less legal obligations. So if you give a person some money without any contract on interest, then that is not a debt as it is supposed to be, because some of the definition of a debt is also includes the interest. So some legal definition of the debt includes also the money given on interest. So now, we are talking about the law that governs, or the laws that governs the debt correction. Now, as I said, the first thing that has to be there, which has to be established, is that there is a contract between the lender and the borrower. So you agree upon certain terms, you agree on certain obligation. So what is the obligation, what are the obligations set? I'm going to give you the money and you are going to give me on 30th. And you should also set, what about if you don't give me on 30th? What am I going to do? So you have to say, okay, if you don't give me on 30th, I'm going to take this action. So that is uh, the obligation. That is that is the law. When you are talking about in the when one is collecting the debt, has also to know that one who is owing that person is not a criminal and has got all the human rights, because in many cases in the debt correction in the communities, they want to make that person to be to look hard or to deprive that person of his rights, his freedom, and other things that are supposed to be taken. Now, in the laws that governs in the collection of debt, there is uh, there is nothing like getting you should not be the bailiff when one is owes another person, and this person, since you owe me, I'm going to take the TV. So immediately when that TV is taken, it becomes theft. Someone is owing you, you go and pick something from that person, and when you do that, that is theft. So anything that like any time that you are collecting the debt, there must be agreement. Did you agree that if I don't pay back, I'm going to collect the TV? If you did not agree, then you cannot collect it. Then if you agreed on that one as a collateral, you agreed on that one as a collateral, then that can be done. So in debt correction, if there was an agreement on the collateral, you can collect that thing that you agreed upon. But if there was no agreement that in case of default, you are going to get something from that person, you cannot do it until there is the court order to do that. So it is only the court that has been given the mandate to order default, distress. Then, in the case that the court has ordered the bailiffs or has ordered which is called the default distress, then there must be a procedure that has to be taken. And number one, the court gives 14 days for one to pay back the loan, or else the issuance of default summon can be ordered, or the issuance of distress can be ordered, whereby now the bailiff can come and collect your things. Now, in Zambia, we have got the law that gives the private bailiffs, and also there are those that are called the state bailiff. So when you decide to use the private bailiffs, they have got also some laws that they are supposed to abide by. Number one, when they are going to collect the goods from that person who owns, there must be the default where the court has given the order. Now, where there was no judgment that this person has defaulted and the court has given the order of distress, then that can never be applied. The bailiff, whether private or any court bailiff, whether private or state bailiff, they cannot collect if there is no order from the court and there was no judgment from the court. Unless, as I said, there was you agreed on the collateral, and now that has not been done, then you know that this person can overpower me, then you can use the bailiff. But where there is no such anything collected from the person that owns you, it means that you have stolen. You may even be charged of robbery, because robbery, it is whereby you grab something on site where a person is seen. So that's some of the rules. So what are the procedures as you must take if someone is owing you and there were some agreement? Number one, you have to write that person. You can use first a verbal. You go there. You said, "Can you give me the money?" Or "Can you give me yes the money?" Then, if that person doesn't respond to that, you have to write that person. You write that person and tell him, I'm giving you 14 days that you should pay back what you took. And if that person doesn't uh, act upon, you should also write him that since you have not paid back, I want you have to pay me with interest on such a day, because you have not honored the time. So I've made the loss and you have to pay with interest, or else I'm proceeding to court. You give the person again the 14 days. And if that person cannot honor that, then you have to do the default summon. You have to go to court, then you have to sue that person. So in the default summon, we'll talk about the courts that you can go to when you want to get your debt. So in the default summon, there are three options that are given to the borrower. Number one, he can agree to pay the debt right there. So you just say, no, I'm willing, I'll be able to pay the debt. Then if he has acknowledged that, he can also apply on how he is going to pay the debt to the court. Then the second, there is counterclaim. Then even that person may say, this person owes me as well. So there is a claim that the one has. I'm not going. I've delayed in giving because of this and this and this and this and this and this and this. So there is what is called counterclaim. So the person can respond from the default summon by counterclaim. Then the third is that if that person doesn't respond for a certain period, which is mostly 14 days, then the court will pass judgment against that person, that person has to pay. And when the court passes judgment, the judgment can be affected within 14 days if that person doesn't pay back the money. Now, in doing that, the summon has to be given. I said the first, you have to write that person. You remind that person again. Then you file the case in court. After filing the case in court, then the person will have three options. And if that person doesn't respond after 14 days, then you should inform the court, and the court, you should apply that the court passes judgment. When the court passes judgment, then the court is going to issue distress. You should also apply for distress after 14 days. So now, every document has to be given to the respondent. You are an applicant, so you have to give the default summon, and there must be a proof that that person has received. Then, if that person has not responded, you should also give that person the judgment that has been given in court, so that that person is aware that the court has passed judgment. And if the court has passed judgment, that person can go and appeal and give the reasons why he did not appear before court. And again, that is the one which is given again 14 days. Or a person may decide to pay within that period that has been given, which is 14 days. Now, failure to do that, as a uh, as the one who is suing, as the one who is suing the applicant, then it will mean that you, as the one who is suing, if you have not done your obligation, that person will the court will not enforce the law. So, in short, I'm saying the applicant is called the plaintiff. Then the respondent is called the defendant. So now these words are used interchangeably in court. It depends with the court, but in the civil jurisdiction there is the defendant and the plaintiff, which is the one that is owing is the defendant, and the owner of the money is the plaintiff. So now in this after all this has been done, you have followed the legal process, then the court has the court gives you the default. You can take it now to the bailiffs, then the bailiffs will take action, then your money can be recovered. And but in the long run, where this person applies to the court, the stop order, there must be also other many documentation which we are going to do in the advanced course. There must be many documentation that has to be done. The law of debt collection has a lot of work in the civil jurisdiction. There are a lot of documentation, there are a lot of work, there are a lot of procedures that has to be done. There is also where you go to mediation, whereby you just have to go and speak, and someone mediate you to make a decision, and if the mediation cannot work, that's when the case goes to court. So there is a lot of procedures that is done when it comes to debt collection. So then I think we have talked about almost every subject. I think we have touched on debt jurisdiction, enforcement of judgment, illegal debt collection. So on this, although I did not talk about them, but there is not much to be covered. So I'll give you as the assignment on these subjects. So we said debt is law is one of the most crucial laws, and as I conclude, I want to talk about the on enforcement. Now, here is the situation whereby this person owes you, and he has no capacity of paying you back. So in such a case, there is nothing that can be done. If the bailiffs, if the court gives the judgment, then the distress is made, and that person is the what is collected cannot amount to your money. That means that there is nothing that the court can do, and there is nothing that you can do. That person cannot pay you, and that can never even be turned into criminal. And since you have not paid, then you are going to be jailed. No, there is nothing like that. So if my property cannot match how much I owe you, and all my properties are taken, then you have no there is nothing that you can do. Then you should just count it as a debt, as a bad debt. The other thing is that in debt collection, there is nothing like collecting things that are called essential things. Like you cannot collect the clothes from the person that owes you. You cannot collect the bed if he only has one bed to a person that owes you. You cannot collect the pots. You cannot collect the stove. You cannot collect. So those are restricted. The bailiff or anyone that uh, anyone that is owing you, you are not obligated to get those things. Those are the needs. So you cannot get a person the blankets because he owes you and he has failed to pay, and he only has the blanket. Then so you are going to get that blanket. No, there is nothing like that. So if that person is incapable of paying the debt, then you can apply, the court can declare that person bankrupt. It means that that person cannot do anything, and he has cannot do any business, cannot work, he cannot do any business, because that person has no capacity to be able to do that. So the value, it means that that person is below par, meaning that that person is as good as a person who is buried. So that is what that is the only way and to the extent that the debt can go. Then there are also debt networks. When you owe, there's like these companies that gives out money. There is the debt data, whereby if you owe, for example, Barclays Bank, then you think you are going to get the money from another bank. It is impossible, because there is your name is in there. So any organization that deals in giving out of loans, there is a central data base, whereby if you borrow some money, you are entered into that database, and you cannot be allowed to get the money from anywhere. So if they will be able to search and find that you owe. So bad debt name, it affects somebody. So that is what has to be understood, and that is what has to be known. Like there is this whereby a person borrows from the MTN, Airtel, or Zamcash, and you think you are safe. You are not safe. You can be blacklisted in the issues of debt. Okay, thank you so much, and have a great day. May you continue to research.
Remember to like the video and also to subscribe to this YouTube channel. God bless you.